Thank you for all coming today. So we are here to announce several new measures the Hennepin County Attorney's Office has put in place to ensure that we are complying with our legal responsibilities under the United States and Minnesota-State Constitution to ensure defendants receive fair trials. These measures relate to legal requirements which we often call Brady and Giglio. Those are actually the names of two United States Supreme Court cases that mandate that we as prosecutors have to give certain types of information on certain types of evidence to the defense that might be favorable and material to the defense regarding a particular witness. That means that if we have information that could increase the probability of the defendant's innocence, we are required to turn it over prior to trial. It also means that we as prosecutors have to be proactive. Even if we don't know about that evidence, we have to be out there asking our police chiefs for it. We can't just sit back and wait until that evidence comes to us. Often compliance with these requirements relates to sharing information that could impact the credibility or believability of the state's witnesses, including law enforcement officers, although this doesn't only apply to law enforcement. That's what has made the engagement of law enforcement agencies so critical to the processes we have implemented and are announcing today. When I ran for this office in day one, I pledged to build honest, transparent relationships with law enforcement. We won't always agree, and we haven't always agreed, but we have these honest, candid conversations. And I'm proud to say that I believe we've accomplished that. This has been a critical part of developing these processes the last several months. In other words, what I'm saying is I could have come in and just said, this is going to be our Brady process going forward. But that's not what we did. We worked with all of our law enforcement agencies. There are over 35 of them in Hennepin County, and we all partnered on this. We got feedback from them because we wanted to make sure this was a process that worked for them as well. While the law gives our office significant power to prosecute criminal conduct and restrict freedom, the law also imposes on us significant responsibilities to ensure defendants receive fair trials. Fair trials are the bedrock of our criminal legal system. If a defendant does not receive a fair trial, a conviction can be overturned. Overturned convictions can mean that a person who has committed a crime and inflicted harm is not held accountable, or that an innocent person was wrongfully convicted. Without fair trials, the public will lose confidence in the system and can't be expected to look to the system for justice. The measures we're announcing today strengthen the cases we prosecute, improve training for law enforcement, and protect the rights of criminal defendants. The way in which these changes came about marks the beginning of a new way of partnering with law enforcement to ensure the integrity of prosecution. This process is about accountability, both of our law enforcement officers and our prosecutors. I'm joined today by Brooklyn Park Police Chief Mark Bruley, we've been working with his police department as well as other police departments in Hennepin County. We have worked closely with them for months on this Brady process, and I'm very grateful to all of their work, particularly yours, Chief Bruley. Chief Bruley has been very outspoken in what he thinks is an appropriate process here and has been tremendously helpful to us. You have demonstrated a deep commitment to ensuring that these legal obligations are fulfilled and to making sure that we can deliver a fair process in the legal system, and I want to thank you for your partnership. We have provided all of you in the media with written information, and we are happy to answer questions, so I won't go on too long, but just briefly, here are some of the steps we're announcing today that we have already taken. We have established a new division of professional standards. This division is responsible for internal training in the office and ensuring the office is fulfilling its legal responsibilities in criminal cases. Clare Diegel is the director of that division, and she's led the work that we're discussing today on Brady. Clare's efforts have been supported by several other members of our staff, some of whom have been in the office for decades and some who are newer to the office. One of those newer attorneys to our office is Sierra Milius. Sierra, who is here today, is an attorney with expertise on Brady who works with our attorneys every day to ensure that we are meeting our constitutional obligations. We have also created a new process to ensure that the office is disclosing Brady and Giglio information that is not considered public under the Minnesota Government Data Practices Act. Neither the U.S. Supreme Court or other legal and ethical rules governing disclosure in criminal cases distinguish between public data and data that might be considered non-public in other legal contexts. As we implement this process, additional practices have been put in place to ensure not public data, private data, is protected by judicial order from improper dissemination. We have revised the categories of conduct that may qualify as Brady Giglio. We have done extensive review of case law, the policies of other prosecutors' offices, including the Department of Justice, and academic research to determine what categories of conduct should be considered potential Brady Giglio that we must disclose to the defense. Relying on this research, the office extended the categories of conduct that may qualify as Brady Giglio. For example, Brady Giglio information may include a finding by a law enforcement agency that an individual was untruthful, engaged in a biased act, or violated a policy or procedure related to excessive force, handling evidence, or recording communications. We have created an interim Brady Giglio process for professional witnesses, meaning law enforcement, that relies on established law. This process, which relates to how and when we receive and disclose information related to professional witnesses, remains interim as the office continues to work with law enforcement agencies and their city attorneys on a permanent policy and revised procedures to ensure the office obtains timely and accurate information. We hired an attorney and paralegal to exclusively focus on compliance with these requirements. And lastly, we created a judicial orders bank. Hennepin County judges regularly issue orders related to the credibility of witnesses, the propriety of the conduct of witnesses, and the county attorney's office's legal obligation. The office now has a system for tracking those orders and ensuring attorneys across the office have knowledge of those orders. This system also keeps law enforcement partners up to date on litigation trends and helps identify areas for additional training. Previously, no such system existed. Before I became Hennepin County Attorney, I did have some concerns about Brady issues. There was one particular instance that highlighted the need for a change in how this office handled Brady. And that was a situation where one of our suburban departments had one officer who had testified on, I think, drug cases. Judges, 5 different judges had thrown out 6 of his cases because of the actions of our. So let me take a step back. So 5 different judges had thrown out 6 different cases. And my assumption actually was that the people in the office knew about that, the police chief knew about it. But when I came into office, I learned some surprising things. One was that the police chief from this department didn't know about any of these cases. He did not know that any of those 6 cases had been suppressed and had to be dismissed. The other thing was that our prosecutors did not know internally about those suppression issues as well. In fact, the attorney who had the 6th case had the public defender's office hand her these 5 previous suppression orders, and she was given 30 minutes to figure out what to do about it. And to me, so at the time, I know that this office, the county attorney's office, was asked, what are you going to do about this particular cop? And the answer was, we're not his employer. To me, that's unacceptable. We are partners in this. We have an obligation to put on witnesses that we believe will be credible. We have an obligation and a desire to partner with law enforcement to make sure that nothing like that ever happens again. We should not be putting on an officer 6 times or 2 or 3 or 4 who testifies in a way that results in cases being dismissed. It makes no sense for our office to operate that way. We want to be good partners with law enforcement. And so what that means is that we are collecting these suppression orders. When one of them happens, we do meet with law enforcement. And I want to point out Mike Radmer is here. When I came into office, I appointed him to be the liaison to all of our law enforcement partners in Hennepin County. So he will reach out to the officer and chief and appropriate supervisor and explain what happened in a particular suppression order. Our hope is that whatever happened there won't happen again. And by and large, it's usually about training. And so we want to prevent that kind of thing from happening. And everything I've heard from all of the police chiefs, including Chief Bruley, is that they want to know that as well. They want to make sure that their officers are testifying in a way that is effective so that we can effectively prosecute cases. So I want to also say that law enforcement throughout Hennepin County has been very enthusiastic in sharing the information that we've asked for. They too want effective prosecution. They want to know, usually what we get from them is, what do you need? We're happy to give it to you. What do you need? So I'm going to turn it over to Chief Bruley now, but I just wanted to close by saying these steps are just the beginning. We have excellent engagement with police chiefs throughout this process, and we will continue that work of engaging with them in other processes we will develop. The people of Hennepin County must have confidence in the fairness of the legal system, and compliance with Brady Giglio requirements is an important part of building that confidence. Chief Bruley?
Thank you. Good morning, everyone. Mark Bruley, Police Chief of Brooklyn Park. I'm going to be much shorter than Mary was. But a couple things I do want to touch on, and probably one of the main reasons I'm here, is prior to Mary coming up with the process that she has and giving us the confidence that we're actually complying with the Brady requirements, I did not have that confidence, and that was the concern that I expressed numerous times, that I don't believe that we were complying in a way that was effective in preventing us from losing cases. And so I appreciate that we took this initiative, and even more than that, I appreciate that we were allowed to participate in it. That is one thing that's been refreshing with Mary, is including law enforcement, specifically police chiefs, on decision making in a collaborative way. We meet routinely and we weighed in heavily, as I've had numerous conversations about this process with the county attorney's office. So I appreciate that, and this is absolutely the right move. And at the moment, I have way more confidence that we are compliant. So with that, I'll stand for any questions.
Chief, could you talk just a little bit about, from the police perspective, how this changes, your job in terms of if one of your officers is going to be testifying in a trial, what will be different for you in terms of business disclosure?
Yeah, probably day in and day out, not much is going to be different. So what will happen through this process is we will be giving the data to the county attorney in advance. They will possess all the data that potentially could be used or will have to be disclosed at a trial. And the county attorney has the requirement to bring that to a judge, do an in-camera review, or to argue that. So for our officers, absolutely nothing would change. Some people may be concerned that, that this data is going to be released in public, and the truth is, for me, it gives me no concern, to be honest with you, that the data that we have and officers make mistakes, they're held accountable. And in that accountability, it sometimes may show up in trials, and should be. And that brings some credibility to the system. And we, as the county attorney had expressed, and I couldn't agree more, we need to have fair trials. And to do that, Brady's one of the requirements that we have to make sure that we're compliant with.
Chief, what specific types of...
Can I just, on that, I wanted to say where I do think this will benefit both police and our office is I had mentioned in that case, the officer who had 6 cases, all that litigation happened right when everybody showed up to litigate that case. And by litigate that case, I mean it was a search and seizure. So I would say on that, our goal is to be disclosing this information earlier. It is to litigate it in front of the judge. In other words, we can disclose it and still go into court and argue that it shouldn't be relevant in a given case and have all of that decided so that when we go to court and an officer goes to court, we're not having to deal with that. And an officer is not being blindsided by questions about it. So I think in that way, it's going to help all of us be more prepared and know exactly what's in and out. Sorry about that.
Chief, if you don't mind chiming in here, what specific types of private data are you planning to send over to the Hennepin County Attorney's Office starting now?
Well, and maybe they could, I'll let her also weigh in on this, but the data that we're sending out right now is all the data that's public. So to be honest with you, it's no different than many of the requests that many of you put into a police department about an individual officer. But in aggregate, we're sending all the data over that's public about an officer. And that's generally speaking the existence of a complaint and the outcome. And that's what we're sending over. Now, there's going to be other data that would be considered private data. So in the weeds of the extent of the details supporting the discipline an officer received. And that may be information the county attorney is going to need, and they're going to have to go through a process to obtain that legally. If I can't hand it over, if it's protected data or private, then they're going to need a judge's order to be able to obtain that, and we've had discussions how that would go.
Can I just jump in on that question? Police departments have different disciplinary matrices, right? And that's their business. That's not for us to tell them. What this does is we have obligations to hand over certain information, and sometimes that information is not public. And so what we're getting at here, and Claire can talk about this more, but what we're getting at here is making sure that we have access to information that is relevant, that we have to hand over, whether it's public or private. Claire, do you want to talk about the private?
Sure. So when we are seeking non-public information to review to see if it fits into one of our Brady Giglio categories for disclosure, we are asking the court to direct an order to the law enforcement agency to turn that information over to us so that we can conduct the review and make the disclosure. So no law enforcement agency is giving us non-public information without a court order.
And I just had a question that I wanted to ask. One of the most recent cases I did about is Benjamin Richardson, the Brooklyn Park man who was released from jail after spending 7 months there. Does that, is that part of the reason why you're here today? Do you have any thoughts on that? Does that come to mind at all?
Not at all, to be honest with you. This is about a process of a legal requirement of Brady that we're required to comply with. One of the reasons I'm here today, again, is because I lack the confidence in the previous administration and how we were doing things. There was many loopholes, and I think we could have done it better. And this process has tightened that up so that we have a process to where we both provide the necessary data to the county attorney that they can disclose, and then also protect the data that by law is protected for private data that we will hold back, and at an order of a judge, if we're to disclose that, we will absolutely bring that forward.
Mark, do you flag officers? How does it work in your office? If someone has a complaint held up and that concerns you moving forward, like, ooh, can we put this guy, man, woman in court as a witness? I mean, do you have a roster and officers that concern you right now in terms of putting them in court?
Absolutely not. I don't have any officers that are concerned I put in court at all. And if we did, they wouldn't be working, to be honest with you. That's a critical component of being a police officer. And if we had those kinds of ethical concerns, they wouldn't be working.
It seems like the Brady Giglio came up in the post-board shared with a prospective employer, or can be shared with the post board? I can't quite remember. But have you guys been dealing with that already?
I know the post board has taken up this topic, to be honest with you. I don't know much more past that, so I'm sorry I can't be more helpful.
So just to be clear, these arguments over an officer's reliability or the officer's pass would happen in a pre-trial setting rather than during the trial itself. Is that how it works?
Yeah, the earlier that we can get that information to the defense, our hope is that sometimes the defense will look at it and decide it's not relevant. But if they do want to bring it up, that they would bring it up, or we would bring it up, arguing that it was not relevant, so that we, in a pretrial, some kind of hearing before the judge, before we actually get to that trial or that suppression hearing. That's one of the goals here. We want to get that to the defense, get it litigated, so that we are all focusing on the actual issues in the case. I do want to say one other thing. We've been working with law enforcement for many months on this, and there's one of the things that I very much respect about law enforcement, and there's been a lot of fear here about what are we going to do with this? Do we have this Brady List? And there was some confusion here because the previous administration, when asked, said that it did not have a Brady List when it in fact did. It had a computer database of instances that should be disclosed. But when I was trying to talk about this, and one of the things we are talking, and Mike does some training with law enforcement, and I do ride-alongs and roll calls. I did one in Brooklyn Park not too long ago. But officers have questions about this. What does this mean for my career? And here's how we are answering that. Just like the previous administration, there is a database, a Brady List, if you want to call it, that of things that we do have to hand over. That doesn't mean it's the end of the officer's career. It is separate and apart from something that some jurisdictions call a do not call list. My hope is that with, let's go back to those 6 cases, that one officer I was talking about. We would intervene after that first one, and we would be having the conversation with that officer and the chief, and we would be saying, here's what the judge saw. And our hope is that we wouldn't see that same behavior. And that, I'm not talking about lying. There's a difference between somebody lies, and as Chief Bruley said, if somebody is lying, he's not going to want that officer on the force. And we're not going to prosecute cases with an officer who lies. But there are a lot of different issues that come up, some of them really involving training. So our hope is that we intervene early on, as we could have, the office could have in that case, in that situation with the officer, so that we don't see that behavior again. So I do want to make it clear there are two big differences here. Brady List, computer-based, do not call list. We are not talking about a do not call list. My hope is that we never end up there. But I also feel some degree of confidence in my work with the police chiefs that if there was an officer who continued to engage in inappropriate behavior or refused to adjust after training, that's an officer that they would want on the force. So we've had these conversations for a period of, I think it was about 6 months last fall. And I think it's fair to characterize it as being very new to people. And some people wanted to know what is different about this. There's always a concern to create more work for us. What exactly do you want? And one of our goals in Clare is really to make this as easy as possible. So I think once people understood what we wanted and what the process was, people are, I will say this with confidence, people are complying. There may be some police chiefs who it was, prefer we would do something different, but I can say with confidence that everyone, all of the police chiefs have been giving us the information that we need. a really long way and a very difficult way. And actually, that's something I think the police chiefs have experienced. And we're that this will put a stop to that. We really do have this obligation to hand over that information. And so our hope is that when the defense sees that we've got this process and gains confidence in it, they will not subpoena particular officers or departments. It's very difficult to get that way anyway, but it creates more work for police chiefs. And we want a really streamlined approach that has integrity and that people can trust.
Maybe it's my turn to interrupt the county attorney now. It's a great point that was made is we've already received many requests from defense attorneys for exactly the data that the county attorney is now getting from us on a routine basis. And so it already is public data. It's all the officers, all the allegations of misconduct, and all the outcomes. Many defense attorneys have requested it, and I have sent that all to them numerous times. Sustained allegations. Yep.
One of the differences, you know, the previous administration had MOUs with departments, and it asked for final discipline. And as a chief, I'm sure can tell you, the chiefs may make a decision about discipline, but then there is rightfully a grievance process, arbitration. It may be many, many months before there's actual final discipline. And that's a piece that we have been missing. And so that's where we can hopefully get that non-public, because it's not public yet, but it is behavior where a police chief has indicated that they are going to discipline, but it just isn't final. Thank you.